I want to welcome to the show one of the sharpest legal minds in Wisconsin. Lucas Vebber is deputy counsel at Wisconsin Institute for Law and Liberty. He's the guy in the courtroom defending Act 10, pushing back against government overreach, and holding government accountable when it steps outside its constitutional bounds. Before Will, he served as general counsel at Wisconsin Manufacturing and Commerce. He's worked in both the legislature and the Walker administration. And today he's going to be giving us the latest on the most recent legal challenge to overturn Act 10. Lucas, it's great to have you on the show.
Hey, great to be here. Thanks for having me.
Thank you. And so let's just lay it down, lay the basics down for those of us who might need a refresher. With Act 10 being around for 15 years, it kind of runs in the background of state government that's been saving taxpayers billions of dollars. Can you just tell us what Act 10 did?
Yeah, absolutely. So you're right. It's been 15 years. Crazy to me that time has flown by that fast. But Act 10 was the budget repair bill
Mhm.
from early on in Governor Walker's first term. So recall that when Governor Walker took over, there were new majorities in the legislature. It was a Republican trifecta. We had been coming off a 2 year Democrat trifecta. That trifecta had run up quite the budget deficit. In Wisconsin, government can't run a deficit. It's illegal, basically. So they had to pass what's called a budget repair bill to fix that. In the budget repair bill, they had to reduce spending. And then, as part of reducing spending, they gave these local governments all around Wisconsin through Act 10 tools to reduce their own costs.
Mhm.
And that was Act 10. So, what Act 10 did was it limited the subjects of collective bargaining and it required contributions to pension funds and healthcare costs by public employees, um, and allowed these governments, local and the state government, to realize some significant savings. And those savings haven't just been realized as part of that budget repair bill, but every year since. We're talking billions and billions of dollars. School districts, tech colleges, local government, state government, all across the board. And it's real significant savings. And I think it's important that what happened here and to understand what exactly Act 10 was,
Mhm.
because what the lay of the land was like before. You would have public unions that would engage in politics. They would then elect a local school board. Basically, they
Mhm.
could endorse
Mhm.
candidates. They could elect who they want, vote for who they want, but then they get to negotiate with those individuals. And it's collective bargaining isn't just asking for what you want and having kind of a good faith negotiation. Collective bargaining actually requires them to listen, to be at the table. They have to come to some agreement. They kind of meet in the middle. So for public sector bargaining, when you get to elect elected officials and then you get to negotiate with them, it's kind of a different animal than private sector collective bargaining. And what had been happening is public unions, for example, were negotiating and requiring that healthcare provider be their own healthcare provider, the
Mhm.
union owned healthcare provider, which they get to basically set the prices for, and it was driving up the cost of health insurance all around the state. So one of the significant savings that we've seen has been on those healthcare costs, and that's just kind of one example of what Act 10 did.
Yeah, that's actually pretty amazing. I think the first thing that stood out to me is to find out that public employees didn't pay for their healthcare, didn't pay or contribute into their pension, and it was being all taxpayer funded. Was incredibly, it was just remarkable that that's how it started. And then, yeah, to go to something where it seems just like a no brainer that if you're working, if you want to contribute something to your retirement, you should have a stake and pay for your health insurance to some degree or another, like basic stuff. So yeah, clearly there's a bad policy to allow public employees to collectively bargain.
Yeah, absolutely. And Wisconsin really was, originally led the way, I guess, on allowing this kind of collective bargaining, and then we led the way going the other direction in terms of getting rid of it. Kind of
Mhm.
a really a failed experiment, I would say, in government.
Yeah, so you were in the legislature when Act 10 debates were going on, when that was going through. I was adjacent. I was working on campaigns, so I saw the protests up close a couple times. But can you tell us what that was like from someone in the building? I think it's forgotten about so
Yeah.
much now, but there was just at any given point hundreds of thousands of people in and around the state capitol.
Yeah, it was a crazy time to be working in the building. I worked for then State Senator Rich Zipper, the 33rd Assembly District, and our office was on the third floor of the South Wing, and just getting up into the office was hard. I mean, the police had kind of secured a stairwell that the protesters hadn't taken over, and you can kind of use that to get up. But people everywhere always shouting at you, shouting not nice things at
Hmm.
you. Anybody who was walking in. it was a wild time. I mean, there were people in the Capitol 24 hours a day at the beginning there. Everywhere you looked, it was protest signs, crock pots full of food plugged into the wall,
Hmm. Hmm.
people everywhere, and again, just a lot of shouting, a lot of vitriol. And it was a wild time to be a young staffer in the legislature. That's for sure.
Yeah, and I know it led to a lot of recalls. And again, someone who was in the campaign side during that time, it was basically being perpetually employed in campaigns. And for the most part, with the exception, I think, of what, two legislators, everyone who on the Republican side who were recalled retained their seats. And one of them, I think, there was one of the fellas. He had a bit of a public scandal at the time that drove his votes down. And then I worked for Van Wangard, and we came within 500 votes, and that district had never held an incumbent. So historically, I think there were some things going against those situations, but overall, the people who voted for Republicans, and especially again, true with Scott Walker, they retained the state Senate, they retained Governor Walker. So,
Yeah, absolutely. And I think Governor Walker's election, especially, was basically a statewide referendum on Act 10, right? I
mhm.
mean, I think he got a higher percentage of votes than he got when he was initially elected. And it just showed that the people of Wisconsin appreciated the tough decisions being made to right size government and save taxpayers billions of dollars.
Yeah, can you talk a little bit about if Act 10 expanded to other states? I thought there were a few attempts to do it at the legislative level, but then I think there were some court things that happened.
Yeah.
Can you kind of walk us through
Yeah.
how that kind of
Yeah,
rippled
so I
out?
don't know. I can tell you that the one of the key provisions in Act 10 was that it allowed public sector union employees to opt out of what's called a fair share payment. So pre Act 10, even if you didn't want to join the union, you still had to pay dues basically to the union. They called it a fair share payment. That's the term that they use. It just required you to basically pay for the union, even if you didn't want to use it. If you were a public employee in a kind of a union bargaining unit. Act 10 got rid of that. And importantly, about 6 years, 7 years later, there was a U.S. Supreme Court case, Janus versus AFSCME, that went up to the United States Supreme Court that actually found that those fair share payments themselves were unconstitutional. They violated the First Amendment. That kind of expanded one of those key provisions of Act 10 nationwide. I know that other states had taken up some collective bargaining reforms. I don't know the current state of all that, but I think one of the biggest takeaways here is that reform to those fair share payments that really went nationwide and is now a constitutional right not to make them.
Fantastic. So yeah, every other state, every other employee's feeling some benefit from what we did in Wisconsin 15 years ago. So this isn't the first time Act 10 has been legally challenged. But it's been repeatedly upheld. So can you talk about what makes this different, or what some of the other court cases, and how we've gotten to this point?
Yeah, that's a great question. So there's been two kind of primary cases before this, right? So Act 10 has been challenged a number of times in both federal court and in state court. So the Seventh Circuit case that was out there, the federal case, was called WEAC versus Walker. The Seventh Circuit issued this decision in 2013. WEAC was essentially a First Amendment and an equal protection challenge. It held that ban on automatic payroll dues for union dues. They brought a bunch of challenges, various challenges to Act 10. One of the primary challenges was an equal protection challenge to some of the classifications made under Act 10. And I think that's kind of key to understanding some of these legal challenges is that Act 10 did not apply equally to all public employees. Act 10 distinguished, they allowed collective bargaining rights to continue for certain public employees, certain public safety employees.
Mhm.
So the earliest challenges to this focused on an equal protection challenge where they brought these things and said, hey, you can't treat groups of employees differently based on the jobs that they do. And they brought that challenge in federal court as well as in state court. So the Seventh Circuit in the WEAC case said, no, that equal protection challenge fails. All the other challenges are failing too. And they upheld Act 10. Then there was a kind of a parallel case called Madison Teachers Incorporated versus Walker that went up to the Wisconsin Supreme Court.
Mhm.
The Wisconsin Supreme Court in 2014 issued a decision in that Act 10 case, holding that, among other things, public employees don't have a constitutional right to collectively bargain, and that things like the recertification requirements that were in Act 10, which is another key provision of Act 10, were not unconstitutional. Um, and without rambling on too much here, but just to
Yeah,
explain
sure.
what that means. So To be a public sector union, to represent public employees under Act 10, the union bargaining unit has to get recertified annually. So, what that means is that a majority of the employees in that unit every single year have to say, yes, we want to continue to be represented by this labor union. And if the union doesn't get a majority of employees in the unit, then it's not certified and it doesn't get to represent those employees. So, it was really giving employees a voice.
Mhm.
And they had to get an affirmative vote of a majority. So if you don't want to vote, your vote counts as a no, essentially. So you have to get a majority of employees, 50 plus one, to speak up and say we want this union to represent us. And that was another thing that the unions had challenged. That again was upheld. Um, and then of course, they also challenged the classifications, and the Supreme Court there again under the state constitution also found that those classifications of public employees did not violate equal protection. So those were kind of the two really big
Mhm.
cases in Act 10, the initial cases. For about 10 years after that, 10 years plus, those cases were upheld, and Act 10 has continued to save billions. There was another effort filed a few years ago in Dane County Circuit Court, essentially retrying this case again. Um, and the Dane County judge in that case actually went the other way. He found that the equal protection challenge was he issued a declaratory judgment that the Act 10 classifications violated equal protection. This was December of 2024, I believe, is
Mhm.
when he did that. But what he did there was not the difference between public sector and public safety and non-public safety. What he said was that the line drawing that the legislature engaged in when they created certain public safety classifications is what violated
Mm.
equal protection. So, for example, the legislature's definition of public safety didn't include certain like UW campus police,
Mhm.
and the Dane County judge said that's irrational, which is the standard he applied in this case, and then struck it down. So, a little bit different than the challenges before, and then that is the case that was very recently appealed to the Wisconsin Court of Appeals, which overturned his decision
Mhm.
and then sent the case back down to him to dismiss. So that's kind of where we are right now.
Sure. And that's you talk about the rational review. That's the rational basis review.
Yeah. Yeah. So when you're, and that's kind of an important part to sort
Mhm.
of understanding some of the legalese here. Don't mean to put the watchers at home to sleep here, but
No, no, we
just to
need
explain.
we talk so much about policy or not policy. We talk so much about the politics and kind of the gossipy stuff about what's going on campaigns.
Yeah.
No, we need to have these conversations about policy, about the legal stuff. We got to, raise the level of debate for our listeners. And
Yeah.
please tell us, give us it all.
Yeah. So depending on kind of the classification that's in play and the right that's being affected, courts will apply a level of scrutiny, which is like basically how close do they look at it, who has the burden of proving it. For example, if there's like a racial classification, that gets the highest level of scrutiny. It's called strict scrutiny.
Mhm.
The burden is on the government to justify that it's narrowly tailored to a compelling government interest, is what we say for strict scrutiny. It's the
Sure.
highest level. It's very difficult for the government to win on that. That's why, on like these racial classification cases, which we've seen a lot of recently, challengers tend to win those. It's not a guarantee you win them, but they tend to win them. It's harder for the government to meet strict scrutiny.
Mhm.
On a case where there's no fundamental right involved, which again, Act 10 doesn't involve a fundamental right. You don't have a fundamental right to collectively bargain. Just, if it just classifies various job classifications, that gets what's called rational basis scrutiny.
Mhm.
That's the lowest level of scrutiny. Under rational basis scrutiny, a challenger has to disprove every possible rational basis to the law to win. It's a very high standard to meet. It's very difficult to win under rational basis scrutiny. It's not impossible to win under rational basis scrutiny. For example, we recently won a rational basis case against the city of Milwaukee involving some food trucks. But in this case, there was existing case law that was very clear that the legislature had a rational basis here. And all that means is that the legislature, when they passed the law or created a classification, the question before the court is it rationally related to a legitimate government interest? Again, very low
Mhm.
standard for the government to meet, but the burden in that case is on the challenger.
Mhm.
So you got to disprove everything. That's why it's so hard to win those cases. Not impossible, but very hard to win. And
You
that's
said. You said you did it with a food truck case.
Yes. Yeah.
So,
We recently brought an equal protection rational basis challenge to Milwaukee's food truck curfew ordinance under the right to earn a living under the Wisconsin Constitution, and we won that on a preliminary injunction motion. So that ordinance is now enjoined. The city tried to file an appeal. That appeal was denied. So we're kind of proceeding on that case, but we won at least a temporary injunction under rational basis out there, which was a nice victory. So.
and anyone walking
Um,
out of the bars at 2 a.m. is thrilled to be able to have something to eat. And of course,
exactly.
those people aren't the ones that are
Yes.
causing the trouble that's been going on
Uh,
down at Water Street.
Exactly. Yeah. In that case, for example, the city's argument was that the food trucks themselves were somehow leading to the crime that was occurring on Water Street. We said that was absolute nonsense. We actually had an expert on food trucks, who's a professor at Wake Forest, who testified for us, who said not only do food trucks not cause crime, but the empirical evidence actually shows that food trucks prevent crime. Because when you have more people, more eyeballs in the area, it tends to reduce crime overall. So, just
Amazing.
having more people there, food trucks are attracting more. It's
Oh,
going to
look at
lead to this
again,
volume. So, anyways, a very
standing up for small businesses. It's an important part of what you guys do.
Yeah, absolutely it is. It for sure is. And when you're in this kind of rational basis land, is what we call it, it can be really tough to bring these cases, and it can be really tough to win them, but it's not impossible. And in the Act 10 context, again, these issues have already come up in courts. They've tried arguing them time and time again, and lost. And so, I think it's pretty clear that there's a rational basis here. But again, what the court found was that the legislature's line drawing in terms of who classified as a public safety employee within traditional public safety professions like the UW campus police, for example, were not included. And he just said that's irrational, and
Mhm.
he kind of second guessed the legislature's line drawing there and said it violated the Wisconsin Constitution. So
Wait, you're telling me for the
that was
first
the
time,
decision that.
you're telling me for the first time ever that a Dane County judge has decided to write state statute. Never happened before, right?
So,
So,
yeah, I mean, this
yeah.
one, like I said, we obviously respectfully disagree with the decision with him, but yeah, it was one that we thought was just an incorrect decision, and are certainly happy with the Court of Appeals decision that reversed it.
Yeah, I really appreciate you kind of walking us through that because, as an outsider, as someone who doesn't have a legal background, you see Dane County Circuit Court judge shoots down or rules something that was written by the Republican legislature to be unconstitutional. You just kind of roll your eyes and figure, yeah, of course, that's what happens. That's what Dane County judges are elected to do, unfortunately, or expected to do, I guess you could say. But in this case, it goes up to the Court of Appeals. Could you walk us through why it was rejected at the Court of Appeals, and then what happens
Yeah,
next?
yeah. So first, Wisconsin's Court of Appeals. So we have four Court of Appeals in Wisconsin. It's really one giant court, but four districts. So each district covers a set number of counties, geographic areas. So Milwaukee County is its own district. That's District 1.
Mhm.
Dane County is the kind of southwest Wisconsin and the southwest Wisconsin counties. That's District 2. I'm sorry, District 3. District 4. Wow, I'm sorry.
It's okay.
District 4 is Dane County. District 3 is up north. And then District 2 is kind of the eastern southern part of the state, kind of suburban Milwaukee in that area, which would
Mhm.
include like Waukesha County, Washington County, that area. So when you file a lawsuit against the state of Wisconsin, and the state is the sole defendant in that lawsuit, which is the case here, as the plaintiff, you get to pick which county you venue that lawsuit in. You
Mhm.
get to pick where you want to file it. So the plaintiffs here chose to file it in Dane County. Um, when you make that decision, it impacts where you can appeal, because the appeal has to go to a district outside of the district that your county that it was filed in was located. So Dane County being in District 4 meant the appeal had to go anywhere but District 4.
Mhm.
So the appellants here, which was the state legislature, I believe, and our clients, they went to District 2,
Mhm.
and they filed the appeal there in District 2. District 2 then had briefing on the case. It was fully briefed out, and once they take all those briefs, the Court of Appeals rarely hears oral argument in cases. They typically just make decisions on cases based on the briefs that are submitted by lawyers.
Mhm.
That's what happened here, a pretty typical case. And then they released this decision earlier, a few days ago, that said they reversed the Dane County Circuit Court, sent the case back, remanded it back with instructions to dismiss the complaint. The decision itself is what we call a per curiam decision. So the Court of Appeals, each Court of Appeals case that comes up in Wisconsin gets three judges, typically a three-judge panel that's going to review it. If one of those judges wants to be the author of that opinion and put their name on it as the author, um, that opinion can then be recommended for what we call publication. If it's recommended for publication, it has precedential value. If it's accepted for publication, it has precedential value and can be cited going forward. A per curiam opinion is essentially what we call an unauthored opinion.
Mhm.
So in this case, it was a per curiam opinion. There was a dissent from Judge Neubauer, who's leaving the
Sure.
court.
Yeah. Hmm.
She's off the court now, but she wrote a dissent in there on a per curiam opinion, which is, you don't typically see a lot of dissents from per curiam opinions. It's sort of an interesting one, but I just
Hmm.
wanted, a little legal nuance there for people. But the actual decision itself, I mean, it's per curiam, and likely because it's just so common sense. It's just, hey, this is clearly, the previous MTI v. Walker case obviously applies here. There's a rational basis. We're just going to dismiss this. It wasn't anything that really warranted any kind of precedential setting opinion from the Court of Appeals, and it was a well written opinion that was, true to the law. And
Hmm.
so, that's where we are now on it.
Yeah. So procedurally, what happens next? You said I think it goes back down for dismissal, but is that
Yeah, it'll
the?
go back down for dismissal, but the plaintiffs here will have the opportunity to seek review from the Supreme Court of
Mhm.
Wisconsin. So the way that works is you get 30 days once the Court of Appeals decision comes out to file what's called a petition for review. The Supreme Court in Wisconsin doesn't have to hear any case it doesn't want to hear.
Mhm.
The Court of Appeals has to hear every single appeal that gets filed, but the Supreme Court, which is the highest appellate court in Wisconsin, gets to pick which cases it wants. So if you are a loser at the Court of Appeals level, you get to seek review. It's called a petition for review. You basically file a brief with the court that says all the reasons why you think they should take the case.
Mhm.
I expect that'll probably happen here, almost certainly is going to happen here. So they file that. The other parties get to respond to that petition for review. The first decision the court will have to make on the case is whether they even want to hear the case or
Sure.
not. In this case, the court could decide they don't want to hear it, in which case the Court of Appeals decision stands, and then the case would be dismissed. If they do want to hear it and they accept it, accept jurisdiction over the appeal, what they would do is order briefing on it. So
Hmm.
there'd be a briefing schedule on the case, and then once it's fully briefed, the Supreme Court would hear oral argument on it at their courtroom in Madison. They would then write an opinion after that. It would probably, I would expect under the timeline now, if they file a petition for review this month, um, it'd be briefed out over the fall. There'd be oral argument sometime, probably in the new year, and then a decision sometime like June of next year would be my guess. So, obviously the court can move as quickly as it wants to or as
Hmm.
slow as it wants to. I mean, they're kind of the boss on this, but that's just kind of a typical timeline of what to expect. So.
Okay, so it isn't necessarily over for the plaintiffs, and in this case, which is a bit unfortunate, because tell me what happens for everyday Wisconsinites if the plaintiffs win, and Act 10 would
Yeah,
then
so
essentially go away.
Yeah, if Act 10 goes away, we're talking billions of dollars in costs that get shifted back onto taxpayers.
Mhm.
So again, we go back to the land we were in pre-Act 10 here in Wisconsin, where these public employee unions get to come to the bargaining table and make kind of demands like, hey, you have to buy health insurance from our health insurance company, and the cost of that's going to go up, and that cost has to be borne by taxpayers, right? I mean, we're the ones who foot the bill for that. The Wisconsin Institute for Law and Liberty, my team, Dr. Will Flanders on our staff has put together a wonderful tool on our website where you can type in where you live, and it will tell you what the impact is projected to be if Act 10 goes away for your community.
Wow, we're
You
gonna
can
have to
see
make
exactly how
sure
much.
we add that to the Heartland Post website. Make sure that that's out there. Thank you for doing that. That's huge. I think people really
Yeah, it just
understand.
helps.
Yeah.
Yeah, it just helps add some context to
Hmm.
it, and I think we'll kind of see where it goes. The Wisconsin Supreme Court has a long history of respecting precedent and upholding that going forward. And so, I think the precedent here is pretty clear. And so we'll see what happens on this petition for review, assuming it gets filed, and then ultimately what they want to do with the merits of the case. I still think it's a very tall ask for them to say, for any court to say that Act 10 violates equal protection, just kind of given the jurists who have already looked at this and already reached those conclusions. Um, And so, we'll kind of see what happens with it, but I would expect this saga is finally over sometime next summer.
Well, fingers crossed that again the Supreme Court respects the precedent. I know there's probably people seeing the makeup of the Supreme Court now realizing the value that those spring elections have, and candidate quality really matters when you're trying to pick the right people to run for Supreme Court, and hopefully the conservative side gets it together, and we can even things out because I don't have a whole lot of expectations that they'll respect the precedent, but you're the lawyer, you're the one that's argued stuff before the Supreme Court. I'm gonna trust your opinion a bit more and maybe not crash out over uh, the current makeup of the Supreme Court. So
Yeah, I mean, I think our court is tremendously powerful, and I do hope that people who are paying attention do understand that these elections matter,
mhm.
and that those justices have a tremendous say in kind of how the law is interpreted here in Wisconsin and where it goes. So
And we'll find out if what people will find out the hard way if their taxes go up substantially because of the renegotiations that come from this. So, Lucas Vebber, I want to thank you for taking the time today, walking us through this explanation of everything on Act 10. Really important stuff. And like I said, we might talk about the politics side, we might talk about the candidates. You coming here to tell us about the policy side and the legal side really, helps us understand things a bit more. And I really appreciate that.
yeah, thank you for having me. It's been fun.
Awesome.